Well, good morning, everyone. Hey, if I can get a quick sound check from those of you in the description box, if you guys can just let me know that we got good audio. And because I've had issues with that past, and it's probably the issues with this guy right here. So anyways, let me know if we got good audio. We'll wait a couple of minutes, kind of let some people trickle in. Got the Supreme Court orders list already loaded up. So hello, everyone. Good morning. Cheers. Let's get our work week started together. I am William with Washington Gun Law. Thanks so much for joining in. Let's get you guys all to tell us where you're coming from. I know I'm going to have some Illinois folks out there. So good morning to all my good friends out there in Illinois. Listen, this is how we do things. We are gluttons for punishment around here. I don't really know why we continue to do this, but I do like getting together with all of you guys in the morning. Ohio, Boston, Silverdale, Liberty, Phillipsburg, Montana, Illinois. I knew to have some Illinois people. Federal Way, South King County. I'm a Des Moines guy myself. Baton Rouge, love it. Love it. People's Republic of Maryland, Los Angeles, Virginia, New Jersey, Maryland, Maine, Rhode Island, Idaho, Virginia. God, this is awesome, guys. I so much appreciate all of you being willing to tune in and go through the misery together. So here's what we're going to be doing. At 6:30, the orders list comes out. I will pull it up. I will take a look. Usually the cases that have been accepted for review are listed right away. If we don't see Snope or Ocean State, the two cases that we are most critically looking at on that list, then I'll do a quick word search, see if it showed up in the denials, because the denials can be pages and pages long. And then we'll go from there and figure out what's happening. If by chance the United States Supreme Court has accepted oral arguments, we will only know that oral arguments have been accepted. The case has been accepted. We will not probably know an oral argument date until later today if that happens. Okay, now, before we get to the good stuff, let's go over some warnings, if you would. I have been on the record of saying that I believe that if the Supreme Court was going to deny these petitions, they would have done so already. I think we're on about the 15th or 16th conference on these cases. So I've been on the record, and I've said that many, many times. And I want you to know that I might have been wrong about that, okay? And the reason I might have been wrong about that is for those of you who watched last week's video that came out, I think Monday late afternoon after the orders list, there was two cases on there, one called Apache Stronghold, one called Morrison. Very, very important cases, very important cases. Both of them had their petitions denied. One of them was on 11 conferences. The other one of them was on 14 conferences. So listen, I thought that, hey, if they were going to shoot this thing down, they would have done so already. I want you to understand that history now shows I might have been wrong. So I don't know what we're getting ourselves into. Saw some comments in the comment section before that Duncan may be holding this up. I don't believe that Duncan is holding this up. I honestly don't. I will tell you this, that if these cases are denied, the case that's going to move into pole position is not going to be Duncan. It's going to be a case actually out of Washington State called State of Washington versus Gators Customs Guns. That is a final magazine ban appeal to the Washington State Supreme Court with a horseshit, pardon my language, horseshit ruling. And that case will be petitioned, and it is completely final. And I think it will slide nicely right into pole position on that. So that's just my 2 cents on it. Oh, and then the final thing before we get to the Supreme Court orders list, since we're about a minute or two away from that, is this whole DEA-ATF merger thing. I know it's got a lot of people freaked out. A lot of people are like, it's a terrible idea. And then you ask them why, and they're like, well, just because it's a terrible idea. Okay, we got to expand upon that. The good news is in that video, which was out yesterday, I gave you all some talking points. So if you do think it's a terrible idea, I'll give you some reasons why it is a terrible idea. I also came up with, I think, a much more solvable situation here, much more reasonable solution. And it does not require actually abolishing the ATF, which I know all of you want to do, but trust me, that is a very, very difficult thing to do. Okay, now when you see me looking over here, it's not that I'm multitasking. It's not that I'm ignoring you. I am actually just waiting and refreshing pages to see if the orders list, in fact, is coming up. It's not up yet. We are due any moment. So we will keep refreshing the page. Once the orders list is up, we'll go from there and we'll see where we sit. I will stick around for a few minutes after we're done with our live session today, and we will go ahead and try to get some questions answered. Today's videos, by the way, later on this morning, you're going to get a video about the state of Texas and all the awesome things that they did with their state legislature last session, which just concluded. And then there will probably be another video later on this afternoon about a shooting that took place in Seattle and what it proves. Okay, folks, the orders list is out. Let's go there. Here we go. Oh boy, this is a different one than normal. Certiorari granted. We have 1, 2, 3, 4 cases in which cert has been granted, and none of them are Snope v. Brown or Ocean State Tactical. So now we have to do a word search. Oh boy, what do we got here? We got something here, folks. Folks, Snope v. Brown has been denied. I have a opinion authored. I'm taking a look here. It appears that Snope v. Brown has been denied. Let's see what it says. I'm going to read it right here. The petition for writ of certiorari is denied. Justice Alito and Justice Gorsuch would grant the petition for a writ of certiorari. Statement of Justice Kavanaugh respecting the denial of certiorari. In D.C. v. Heller, this court ruled that the Second Amendment must be interpreted in light of the constitutional text, history, and tradition. The court further determined that the Second Amendment protects those weapons that are in common use by law-abiding citizens. Because handguns are in common use by law-abiding citizens, the court held that the District of Columbia's ban on handguns violated the Second Amendment. The court's later Second Amendment decision in Bruin and Rahimi did not disturb the historically based common use test with respect to the possession of particular weapons. This case primarily concerns Maryland's ban on the AR-15, a semi-automatic rifle. Americans today possess an estimated 20 to 30 million AR-15s, and AR-15s are legal in 41 of the 50 states, meaning that states such as Maryland that prohibit the AR-15s are something of an outlier. Given that millions of Americans own AR-15s and that a significant majority of the states allow possession of those rifles, petitioners have a strong argument that AR-15s are in common use by law-abiding citizens and therefore are protected by the Second Amendment under Heller. If so, then the Fourth Circuit would have erred by holding that Maryland's ban on AR-15s complies with the Second Amendment. Under this court's Second Amendment precedents, moreover, it can be analytically difficult to distinguish the AR-15s at issue here from the handguns at issue in Heller, but so too are most handguns. Skipping ahead, law-abiding citizens use both AR-15s and handguns for a variety of lawful purposes, including self-defense in the home. For their part, criminals use both AR-15s and handguns, as well as a variety of other lawful weapons and products in lawful ways that threaten in unlawful ways that threaten public safety. But handguns. Okay, we're going to go on. In short, this court's precedents, the Fourth Circuit's decision is questionable. Although the court today denies certiorari, a denial of certiorari does not mean that the court agrees with the lower court decision or that the issues is not worthy of review. Well, if they're not worthy of review, folks, I don't know when the hell we're going to get them reviewed. The AR-15 issue was recently decided by the First Circuit and is currently being considered by several other courts of appeals. Well, we're just going to wait and see what happens? I mean, my God, this has been going on for decades now. So it appears that Snope v. Brown has been denied. There is a dissenting opinion here from Justice Thomas, which is, oh boy, here we go. 1, 2, oh boy. Okay, 8 pages long. So that's going to be the video later on today will be about Justice Thomas's dissent. So Snope v. Brown has been denied. Let's do a search on Ocean State. I have a bad feeling. Yep, there it is, folks. Ocean State Tactical versus Rhode Island petition for writ of certiorari is denied. Justice Thomas, Justice Alito, and Justice Gorsuch would grant petition for a writ of certiorari. So they've both been denied, folks. I just want you to know that right now, that there does not appear to be a dissenting opinion or anything like that on the Ocean State case. But on Snope v. Brown, there has been a denial. There are 2 dissenting opinions. This is a bad day. It's a really bad day for those people who are in one of the dirty dozen states that already have these bans or they're thinking about it. Because what the Supreme Court did today, whether they intended to do so or not, is they have emboldened the civilian disarmament states. What you will see now is clamoring by these civilian disarmament states that, in fact, they have won, that obviously the Supreme Court does not want to question the constitutionality of these bans, and we are going to see these bans grow like wildfire. If you are in states that have been flirting with this, okay, the Colorados and the New Mexicos and some of those other states that have been just flirting with this, your day is coming. Your day is coming, and in fact, don't even be surprised if you end up having some special sessions called by the legislature. They are going to go completely batshit crazy here, okay? And this is a license to disarm is what's occurred here today. Why these cases were not accepted, I don't know. The truth of the matter is that cases such as Snope v. Brown and Ocean State Tactical take a long, long way to get to fruition. The attorneys have spent thousands and thousands of hours preparing these cases. These cases have been ricocheting around in the appellate court system for a long time. And this is absolutely a devastating blow to lawful responsible gun owners nationwide. We're going to go back. I'm going to go back and read with you part of Justice Thomas's dissent so we can see that. Wow. Just did not expect. Hey, you know what? I said at the very beginning, you know, those people like this guy right here said, oh, if they're going to deny the thing, they would have denied it already. Okay. For those who said that, this guy here, we were wrong. I'm glad I corrected the record before we got here. Thomas, I'll read portions of it. The Second Amendment guarantees the right of the people to keep and bear arms. When raising a Second Amendment challenge, an individual has the initial burden of showing that the Second Amendment plain text covers his conduct. Once a challenger makes that showing, the Constitution presumptively protects their conduct, and the burden shifts to the government to demonstrate that its regulation is consistent with this nation's historical tradition of firearms regulation. If the government fails to make that showing, the restriction must be deemed unconstitutional. It is difficult to see how Maryland's categorical prohibition on AR-15s passes muster under this framework. To start, AR-15s are clearly arms under the Second Amendment's plain text. We held that the term arms in this context covers all weapons of offense. The Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence. This is all case law. Maryland invokes the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Weapons in common use today for self-defense and other lawful weapons remain fully protected. Okay, well, it's the same old stuff we've been talking about. I could go through it with but you know, you guys can read it for yourself too. We will get a video done probably, for those of you on the East Coast, will be ready to go this evening for dinner time. I actually have to go in a couple of hours. I got to go play lawyer in court for a little bit. So I'm going to go do that. And then I'm going to get back to the studio and we'll go ahead and get a video done. But for those of you online with us today, and I do appreciate all 636 of you who are online with us right now, just to get you up to date, Snope v. Brown, petition denied. Ocean State Tactical versus Rhode Island, petition denied. Let the floodgates of civilian disarmament, let the floodgates of firearm bans, magazine bans, and every other crazy thing happen that could possibly happen. Let the floodgates open, because that's what's going to happen. For those of you who are in any of the dirty dozen states, the states that are just enamored with civilian disarmament, you better buckle up. You might want to get a Redfin account or a Zillow account, because things are going to get pretty salty out your way. Very, very disappointing. I will point out that, as we mentioned, and when we were talking about how we could lose the assault weapon ban case before the United States Supreme Court, we talked about Justice Barrett as being a real critical component of that, and Justice Roberts. And in the names that we've seen so far on the dissenting opinions, let us also notice that Justice Barrett nor Justice Roberts weighed in at all on the side of accepting these petitions. I'm not certain that Justice Barrett is really that pro 2A. I think that Justice Roberts is become a political hack and doesn't want to accept really controversial issues such as that. I don't know. Maybe I'm wrong. There could be a lot going on. Every talking head here in the 2A sphere will have their 2 cents on it. I'm going to take a little time and digest it, read through the dissenting opinion. Like I say, probably later this morning, we'll get back to the studio. We'll get a video done. Probably won't be a super fancy video so we can get it out there for y'all. But listen, so the good news is I'm not going to have to get up super early every Monday from here on out. I already know how bad we got screwed. I can sleep in knowing how bad we got screwed from this point forward. For all of you who were kind enough to geek out with us every single early Monday morning, especially those of you out on the West Coast, because right now it is 6:41. So you like that? Well, let's get up super early in the morning, get all gussied up, get online, and get our balls kicked right in front of the whole country. Let's do that. But we got to do it together. And I want to thank all of you who've been geeking out on this channel. I want to thank all of you who have been supporting this channel. I want to thank all of you who were kind enough to start your work week every Monday for about 3 months now with us. Let us know if you think we should still continue to do a WGL AM, kind of start the work weeks for you with some live stuff. Obviously, we won't have as much juicy material to talk about every week. So I don't know if it really lends itself to a weekly thing. I think you guys probably have better ways to start your work week than getting motivational messages from some, lawyer on YouTube. But anyways, I want to thank all of you guys. I will stay on the comment section down below, but just again, so we all understand, Snope v. Brown, Ocean State Tactical, both of those petitions denied. There will not be an assault weapon ban or a magazine ban case before the United States Supreme Court this coming session. And candidly, I don't know when we're ever going to get one. All right, listen. Everyone keep fighting out there. This is a huge setback. We have lost the battle, but we are going to win this war. So keep fighting out there. Have a very productive, safe, peaceful, prosperous work week. Blessings to you and all your families. Thank you so much for joining us. Let's keep fighting out there. And most importantly, let's stay safe. All right, everyone. Have a great work week. Talk soon.